It's a great honour to be asked to give the lecture this evening. Thank you very much for inviting me. Usually when I stand up and speak in the House of Lords, I'm met by a total stony silence, particularly if I speak on the subject of collective bargaining, which doesn't get a very warm reception there. But this evening I want to speak not as advertised on collective bargaining on the law, but something a little bit more topical, although it contains those elements. I want to talk about the saga of P&O Ferries and labour law. So let me start at the beginning with a story. On St. Patrick's Day this year, the 17th of March, P&O Ferries sacked 786 officers and ratings from their ferries operating to and from the United Kingdom in order to replace them with agency crew on much lower wages and far worse terms and conditions. The deed was done by a pre-recorded video message and hand-delivered letters of instant dismissal. Those on board the vessels were escorted off by hired security past waiting replacement crews in coaches. One crew member, having been woken to be given the news, was given 15 minutes to collect his things. Cabins were emptied of possessions, and one crew member said that it took 15 days before his belongings were returned to him. Long-standing collective agreements were breached and effectively thrown overboard. There was no prior consultation with the seafarers' unions. No prior notice was given to the UK authorities or to those of the countries in which the ships were registered. It goes without saying, of course, that P&O Ferries had registered all their vessels under flags of convenience from Cyprus, Bermuda and Barbados in order to avail itself of the advantage of lower standards than those required of British registered vessels. No warning at all was given to the seafarers. This was dismissal by ambush. Broken laws. The law was broken. The chief executive of P&O Ferries, Peter Hebblethwaite, gave evidence to a parliamentary committee that P&O had a statutory duty to consult the unions, but decided to flout it. He said, quote, "There is absolutely no doubt that we were required to consult with the unions. We chose not to do that." End quote. His purported rationale was that, quote, "the change was of such a magnitude that no union could possibly accept our proposal." Unquote. The real reasons were more obvious. Consultation necessarily requires advance notice before a proposal takes effect, but the company was intent on an ambush to avoid any possibility of industrial action. It was also intent on acting on its decisions no matter what the unions might say. The company also admitted that it broke UK law by failing to give the statutory notice of the dismissals to the authorities of the countries in which its ships were registered. Failing to give such a notice to the UK authorities, had the ships been registered there, the collective dismissals would have been a criminal offence. But the company claimed that it was not a criminal offence to flout the requirement to give notice in respect of foreign registered ships to their respective national authorities. The right not to be unfairly dismissed would also seem to have been broken, given the manner of the dismissal and the lack of consultation. In fact, the dismissals appear to have been automatically unfair, since P&O Ferries outsourced the supply of replacement crew to various agencies. That would have engaged the transfer of undertakings, protection of employment regulations, a service provision change, which means that all dismissals for the sole or principal reason of the transfer would automatically have been unfair. Dismissals also might have been automatically unfair on the grounds of anti-union discrimination, since it may be inferred that amongst the principal purposes was that of ending the collective agreements, ending collective bargaining, and the engagement of non-union crew. The company hasn't admitted, though it appears certainly arguable, that it broke the law prohibiting discrimination on grounds of nationality by selecting almost exclusively UK seafarers for the sack and sparing the much greater number of its non-UK staff. Part of the careful planning by P&O Ferries for this ambush of its workforce was to calculate payoffs for the seafarers of sufficiently attractive size to induce them to sign away their rights to challenge their former employer in courts or tribunals. Such agreements are, of course, lawful if in proper format. These agreements also contain non-disclosure provisions, NDAs, preventing the workers from ever disclosing their side of the story. Each worker was given a 14-day ultimatum to accept the offer and sign the NDA, blackmail, as it was called by some workers. The computations were relatively easy since the compensation, the breach of the rights involved, were mostly statutorily capped, and P&O was prepared to pay the statutory maximum. Tribunal claims, of course, would have been likely to have taken a year to resolve. Litigation always carries the risk of losing, and the amount of that likely recovery below the maximum is always difficult to assess. And in Britain, only half of awards made by employment tribunals are paid in full, and a third of awards are never paid at all. Unsurprisingly, the seafarers, all but one, John Lansdowne, signed to accept the offers of immediate compensation. Mr. Lansdowne's lodged a claim in the employment tribunal. P&O Ferries calculated that the payoffs to crew members would be recouped from future profits generated by the poverty wages and diminished terms and conditions of the new crews. I'd like to say something about the collective agreements. I've already mentioned that they were broken and terminated. P&O Ferries had collective agreements with the seafarers' unions, RMT for the able seafarers, the ratings, and Nautilus International for the officers. There was a recognition and procedural agreement with each of the unions as respectively representing the relevant grades. An agreement was made with RMT, for example, dated the 3rd of June, 1999, in other words, 23 years ago, and it recognizes RMT as representing the ratings, in other words, the non-officers employed on the ferries. It applies to ships manned by UK recruited and permanently employed crew. It contained the commitments usual in such recognition agreements. Let me read to you some of the provisions. Let me just get a drink. It says the parties to this agreement undertake to abide by the terms of the agreement and thus avoid any interruption to the continuity of normal operational service by preserving the spirit of the agreement and using the laid down procedures. The company and the union, in reaching this agreement, wish to establish and operate policies and procedures which will ensure that the company and employees enjoy an amicable, business-like relationship to their mutual benefit. The parties accept the need to maintain and promote harmonious working relationships and effective communications between the company, its ratings, and their representatives. The union will actively promote this objective and enable the company to establish conditions of employment and, listen to this, resolve all conflicts of interest by consultation, negotiation, conciliation, and if necessary, arbitration. The agreement goes on, the company and the union have a common objective in using the process of negotiation to achieve results beneficial to the company and employees. They jointly agree that matters of change or dispute are best resolved through the process of discussion and agreement, or failing agreement, through a process of either voluntary conciliation or arbitration. Prior consultation with the union will take place before any change in the terms and conditions of employment or work practices is implemented. Should the change result in a dispute between the company and the union, the terms and conditions or work practices shall revert to those which applied prior to the dispute, and the change shall not be made until the negotiation procedure is exhausted. This shall apply equally to collective and individual disputes. Final stage of any collective grievance or dispute will be arbitration in accordance with the agreed procedure. The agreement concluded, if either the company or the union wish to terminate this agreement, notice shall be given in writing at least 3 months in advance. Now, pursuant to that recognition agreement, there were, of course, the normal substantive collective agreements regulating the terms and conditions of the crew. They too were terminable on notice, which in that case was 6 months. And they contained disputes procedure, both individual and collective. All of those agreements were intentionally and flagrantly torpedoed on the 17th of March. P&O effectively repudiated the obligation to negotiate, the status quo provision, the explicit disputes procedure. Without saying so, the employer terminated the agreements without giving the specified notice for termination. I'd like to draw to your attention 4 particular points arising out of this saga. Of course, the most distressing feature is the dismissal by ambush, but there are 4 more issues I would like to draw to your attention. The first is that the contemptuous disregard for the long-standing collective agreements broke no law. The collective agreements were not enforceable by the unions under UK law, nor were the procedural elements enforceable by the seafarers. Only the substantive terms and conditions of employment set out in the collective agreement for the employees were enforceable, having been incorporated into the crew contracts of employment. But of course, they didn't include the procedural requirements of negotiation. And in fact, as we've seen, 785 crew members were induced to sign away their rights to enforce these contracts and the terms and conditions contained in them. It's a fact that in the United Kingdom, with the abolition in 1993 of the Wages Councils Act, legal enforcement of sectoral collective agreements disappeared. The United Kingdom's statutory recognition procedure contains no mechanism to enforce the exclusively enterprise level collective agreements which can be achieved under it. In Ireland, enterprise level collective agreements are not enforceable for the same reasons as in the UK, and the statutory mechanism for sectoral collective agreements, established as long ago as 1936, has, as everybody in this room knows, been subject to litigation in the courts and has only recently, last year, been preserved by the Supreme Court. But one of the most fundamental ILO International Labour Organization conventions, Convention number 98, obliges the UK to encourage and promote collective bargaining machinery. Furthermore, the right to bargain collectively has been held by the Grand Chamber of the European Court of Human Rights to be an essential element of trade union freedom under Article 11 of the Convention. Yet further, Article 6 of the European Social Charter imposes on states the duty to take various measures with a view to ensuring the effective exercise of the right to bargain collectively. These provisions were recently reiterated in the Trade and Cooperation Agreement, that is the Brexit deal between the UK and the EU, in which, and I quote, each party commits to respecting, promoting, and effectively implementing the internationally recognized core labor standards as defined in the fundamental ILO Convention, which are A, freedom of association and the effective recognition of the right to collective bargaining. And another part of that article also says that each party commits to implementing all the ILO conventions that the United Kingdom and the member states have respectively ratified, and the different provisions of the European Social Charter that, as members of the Council of Europe, the member states and the United Kingdom have respectively accepted. Notwithstanding these international obligations, the UK permits collective agreements such as those signed between the unions and P&O Ferries to be breached or terminated by breach with absolute impunity. There was thus no legal remedy by which the unions or their members could prevent this employer sinking the long-standing collective agreements, ignoring its obligation to negotiate, ending collective bargaining, and so replacing decades of industrial democracy on these vessels with employer diktat. Now, the second standout feature I want to draw to your attention is related to that. Because whilst on the one hand, the law denied the unions and the crew redress for the destruction of the collective agreements, on the other, it denied them the entitlement to take any industrial action as means to protect those collective agreements. The dismissal by ambush, of course, precluded, was obviously intended to preclude industrial action by the sacked workers. They no longer had jobs in relation to which they could take industrial action. P&O's tactic thus removed the binary choice of direct legal enforcement or direct industrial enforcement of the collective agreements. But traditionally, and elsewhere throughout Europe, freedom of association and the bonds of solidarity have permitted unions to call for secondary action by other workers who could put pressure on the employer in dispute. In the UK, however, this is absolutely prohibited by statute. All forms of solidarity action are banned on pain of injunctions enforced by contempt of court proceedings, which could result in massive fines and sequestration of union assets. That brings me to the third standout point, the law of contract. The poisonous influence of the law of contract, which infects almost every aspect of labour law. The P&O seafarers could be disposed of because they held their jobs on the basis of a contract of employment. This is a relationship which is presented as a freely negotiated bargain between two parties of balanced power. The truth is quite contrary. The power lies with the employer. The terms and conditions are set by the employer on a take it or leave it basis. True, in this case, the unions, by negotiation and the background threat of industrial action over the years, had managed to force the employer to agree improvements to the terms and conditions. True also that legislation over the last 60 years has imposed some restrictions on the exercise of the unfettered contractual power of employers over workers. But what this episode showed was that if the employer could avoid industrial action by instant dismissal of the entire workforce and could avoid the legislative restrictions by paying the limited compensation required by those provisions, then the employer was free to terminate the contract of employment and contract with new workers so as to drive down terms and conditions to the lowest on which workers were prepared to work. The essential feature of contract law enabling this was the right in every contract to terminate the contract in accordance with its terms, coupled with the feature of employment law that entitles an employer to avoid the contractual and statutory obligation to give notice by paying the worker her net earnings for that period of notice. Finally, the fourth and final point that I want to take from this saga is this. The legal focus in commentary has always been, of course, on the behavior of the company which acted so badly as employer. There's no question arising of lifting the corporate veil, as the lawyers put it, to seek redress against the investors who seek to profit from the doctrine of fire and replace. That remarkable special immunity granted to capitalists, which protects individuals who profit from wrongdoing, is so deeply ingrained that few question it. Thus, there's no question here of pursuing DP World, which owns all the shares in P&O Ferries, based in Dubai. Just as the investors are protected from liability, so are the directors. True, the government is disqualifying Hebblethwaite as a director, but there's no question of personal liability attaching to him or the other directors for their conscious decision to break the law. Section 172 of the British Companies Act requires a company director, quote, to act in the way he considers in good faith would be most likely to promote the success of the company for the benefit of its shareholders as a whole, unquote. Though in doing so, he must also, quote, have regard, amongst other matters, to the interests of the company's employees. Having had regard to the interests of the employees, in this case, Mr. Hebblethwaite was then free to dismiss them and give precedence to the interests of the shareholders without the possibility of being personally liable for those decisions. The failure of the law. So we see that in this sorry saga, United Kingdom labour law failed utterly to protect the jobs, incomes, careers, and industrial voice of these workers. I don't know that Irish labour law would have done any better, but no doubt you'll tell me if I'm wrong. In the first place, this failure was because the rights of the workers, dependent on contract law and weak statutory protections, were so limited. In the second place, the mechanisms by which such rights are enforced offered negligible restraint against an employer prepared to pay the easily calculable cost of statutorily capped compensation for flouting those rights. Globalization. Sacking entire workforces in order to replace them with cheaper labor, with lesser rights, and often no union organization, has a long history in labor relations. Globalization in modern times has facilitated such practices. The use of labor from less well-developed economies to displace workers in more developed countries, the very states where higher wages provide the market for the goods and services of the corporations seeking to exploit the cheaper labor, has become more and more frequent in recent years. Indeed, shipping was one industry which led the way in this practice. Mr. Hebblethwaite told MPs that the company needed to move to quote a competitive operating model that is recognized throughout the world and our competitors also used. His reference to competitors was doubtless a reference to Irish Ferries, which in 2005 sacked, albeit with consultation, hundreds of crew in order to replace them with foreign agency workers on low hourly rates on the Holyhead, Dublin and Rosslare Pembroke routes. But uppermost in his mind must have been the fact that in June 2021, Irish ferries using this crewing model started sailing between Dover and Calais, the main route operated by P&O Ferries. It could therefore undercut P&O Ferries, especially on freight. The ILO Maritime Labour Convention of 2006 has sought to balance the conflicting interests arising from the international differentials in wages and living costs, as indeed have the European Union Seafarers Directives. But in the face of resistance by the global ship owners cartels and with the complacence of governments, Western European collectively agreed wage levels, terms and conditions have not been protected. The international transport workers, the ITF, has been fighting a losing, though heroic, battle on this front. The consequence of the exploitation of differential wages, terms and conditions is naturally a race to the bottom. P&O Ferries initiative is likely to serve as an exemplar for other companies to follow suit. The government response. UK government ministers acknowledged the disgraceful conduct of P&O and pledged to take action. They said that they would implement a robust package of measures that will force P&O Ferries to fundamentally rethink their decision and protect ferry workers in the future. Well, you can be the judge of that. Having defaulted on a promised employment bill in the Queen's speech of 2019, and having apparently on Mr. Johnson, the Prime Minister's personal intervention, overruled the proposal of his cabinet to include an employment bill in the Queen's speech, which is to be delivered on the 10th of May of this year, it's perhaps not surprising that the government didn't propose any significant changes to employment law in response to the P&O situation. Nonetheless, 9 pledges were announced by the Minister, Grant Shapps, on the 30th of March. None of these proposals has saved a single job of those that were lost. All the proposals only operate for the future. As far as the government is concerned, the sacked seafarers were a lost cause. Of these future measures, only one will put any remedy in the hands of the workers or their unions. All the rest are dependent on the intervention of third parties. Yet surely the fundamental issue here is the fact that workers and their unions had no powers, legal or industrial, to restrain the abhorrent conduct of the employer. Now, I propose to say a word about these measures, but I'll be as brief as I can, except when dealing with collective bargaining. The first proposal of the government was to extend the national minimum wage to ferry workers, and a second proposal calls on the Inland Revenue to dedicate significant resource to check that ferry workers are being paid it. Well, I'm sure that's a very good thing. It would certainly significantly increase the wages of most of P&O's replacement crews, and it's the only measure which puts into the hands of workers the means to enforce it, in that case by litigating underpayments. However, it needs to be borne mind that the national minimum wage would have been a savage wage cut had it applied to the dismissed P&O crew who are on much better wages. But since they've been sacked, the measure is of no relevance to them anyway. The effect of imposing the national minimum wage more widely will be to undermine the agreed rates for ferry companies which have not adopted the P&O strategy. It will fortify the argument for the exclusion of wages from collective bargaining. But for P&O Ferries' new crews, this latter point is immaterial, since of course there will be no collective bargaining on any subject as far as they're concerned. Third government proposal was a new code of practice, as yet unpublished, even in draft, on fire and rehire. Amongst other things, it said that this would allow tribunals to increase compensation for unfair dismissal by 25% where the code has been breached. Code of practice is, of course, not law. It will not, therefore, introduce the legal levers necessary to restrain group dismissals without prior consultation. It's just a code of practice. Earlier this year, the government talked out a sophisticated bill that would have implemented legal levers by, for example, giving workers dismissed without consultation the right to obtain an injunction to compel employers to fulfill their duty to consult. As to the 25 uplift of the award of unfair dismissal awards, that clearly is not going to deter an employer prepared to break inconvenient laws. If compensation is to be effective as a deterrent, then the cap on compensation should be removed and full compensation commensurate with actual loss required. Furthermore, to have real deterrent effect, a penal enhancement in excess of the value of the worker's loss should be permitted for aggravated and exemplary compensation. And awards should be enforceable personally against directors complicit in a breach of the duty to consult. It's relevant here just to mention criminal sanctions, which of course the government proposals do not mention. It's not even proposed to make non-reporting of collective redundancies to foreign flag registries so as to have some equivalence with the criminal sanction of an unlimited fine for not reporting to the UK or authorities. But there's a greater irony here. Statute imposes a criminal liability with an unlimited fine for failing to report collective redundancies to the British state, but gives the British state no powers to do anything by way of redressing that failure. Yet on the other hand, no criminal sanction is thought to be appropriate for failing to consult the workers to be made redundant. To say that that's unbalanced is an understatement. Fourth government proposal is to give harbour authorities power to refuse a berth to ferries which don't pay the minimum wage. That proposal is being opposed by the port operators. And considering that Mr. Hebblethwaite turns out to be a managing director of Larne Harbour Limited, and that P&O's parent company operates terminals at London Gateway and Southampton, it's to be wondered if this proposal will become effective. Surely a more effective measure would be, in the event of a failure to pay proper wages, or indeed to consult whether there's a statutory duty to do so, to give unions the right to apply for that most traditional maritime remedy, and one I know it's dear to Matt Kelly's heart, a warrant for the arrest of the vessel, pinned, nailed to the mast of the ship to prevent it leaving port. Fifth measure from the government is to encourage the Maritime and Coast Guard Authority to rigorously check safety on P&O ferries, which they have been doing. 3 ferries were detained, and I see that last night the first P&O ferry to sail since the 16th of March actually managed to get out of port, having been cleared. Sixth measure was that the Prime Minister, having personally called for the resignation of Mr. Hebblethwaite, has now referred the latter to the Insolvency Service to investigate his fitness to be a director. Seventh measure is a curious one. It is to invest £2.3 million to support seafarer welfare, skills and training and promote maritime diversity and careers. No doubt that's welcome, but the lack of welfare skills and training were not at issue in the P&O Ferries scandal, and the investment, useful though it may be, must seem bitterly ironic to seafarers who, far from having their careers promoted, have instead lost the jobs for which welfare skills and training might have had some relevance. But this proposal goes a little bit further, because the government pledges to pursue, and I quote, international agreements at the International Labour Organization, covering an international minimum wage, a global framework for maritime training and skills, and tools to support seafarer mental health. Now, it's, to say the least, surprising to hear that a Conservative government is proposing to push for worker protections at the ILO, considering their long history of opposition to such members. It's to be wondered just how significant this proposal will be. The Minister seems to be completely unaware of the extensive existing provisions of the Maritime Labour Convention, which covers maritime training and skills in great detail. Further requirements on these subjects may be welcome, but it's to be wondered what they might be, given the extensive consideration the ILO has already given them. Naturally, any international measures to enhance and protect seafarer mental health, which suffered so considerably during long confinements on vessels during COVID, are to be encouraged. But the proposal for an international minimum wage is one that the ITF have wrestled with for decades, and if achievable at all at the ILO, is likely to be far below the level of the UK national minimum wage, and most unlikely to be of the slightest benefit to UK seafarers. It's the eighth proposal that is the most encouraging. That is that the UK, France, Denmark, the Netherlands, Ireland, and Germany should discuss how maritime workers on direct routes between these countries receive a minimum wage and the creation of minimum wage corridors. This is encouraging because it's likely that such minimum wages will be well above the level of the UK national minimum wage, which is one of the lowest in Western Europe, and because these countries are likely to be supportive of the idea of protecting their ferry services from undercutting by outfits like P&O. It'll be recalled that the EU is currently engaged in negotiating a draft directive requiring member states to apply national minimum wages, including by means of collective bargaining, as in the Nordic countries. Indeed, the draft proposes that member states in which collective bargaining is available to less than 70% of the workforce should take active steps to promote it. Furthermore, the draft explicitly forbids the undermining of collective bargaining or collective agreements on wage setting. It's disappointing that the minister didn't reference the draft directive, nor that Denmark, Sweden, Norway, and Finland should have been included in the government's list, since those countries, which of course have got ports to which ferry services from the other countries run, have the highest wage rates, terms and conditions, and the most effective mechanisms for enforcement of seafarers' terms and conditions, including by union inspections. A further aspect of this proposal, though, is truly remarkable from a post-Thatcher Conservative government. It is that the Secretary of State will be, quote, asking unions and operators to agree a common level of seafarer protection on these routes. In other words, those between the countries listed above. To agree a common level of seafarer protection. More remarkable still, given the antipathy of the government to unions, is that this proposal appears to mirror the Fair Ferries strategy drawn up by Nautilus International, RMT and industry partners. It's strange, but nevertheless welcome to hear a UK government give a favourable mention to sector-wide collective agreements, considering that for over 40 years, they have effectively declared war on them. Wages Council legislation was repealed. Fair wages resolutions of the House of Commons, which operated through public procurement, were abolished. The duty to promote collective bargaining was removed from ACAS. Government and media worked hand in hand to encourage derecognition and the ending of sectoral agreements by employers, starting with the media. Government policies of deindustrialization by encouraging capital to move productive capacity out of Britain to exploit cheap labor in developing countries destroyed many British industries with dense levels of collective bargaining coverage: garment making, hosiery, shipbuilding, steel making, coal mining, quarrying are obvious examples. The government policies of privatization and outsourcing also contributed significantly to the demise of sectoral collective bargaining. Let me just remind you that collective bargaining coverage prior to the election of Mrs. Thatcher in 1979 put the UK amongst the leading countries in Europe. By 1970, coverage was at about 78% of the workforce and still rising. It rose to a peak in 1975 of about 85%. Of that, only about 10% of workers were covered only by enterprise bargaining. The rest were all subject to sectoral collective bargaining. But from 1980, the extent of collective bargaining coverage in Britain has declined dramatically. The latest figure marking this shocking decline is the estimate for 2019, which puts it at 26.9%. A realistic estimate for today is probably less than 25%. In other words, only 1 in 4 British workers has the benefit of a collective agreement. So against this background, international sectoral collective bargaining in the ferry industry, backed by government, is a solution which the industry ought to be crying out for. What could be better than a collective agreement for the sector negotiated between all the employers and unions in that sector, setting minimum wages, terms and conditions, so that one ferry company cannot undercut another by reducing labour costs. Sectoral collective bargaining would be consistent with Labour Party policy. Sectoral collective bargaining was the norm throughout Europe and remains common. As noted, the EU has now declared itself in favour of extensive collective bargaining coverage by the draft directive on a minimum wage. That seems to reverse a period during which austerity policies caused the Troika Commission and the IMF and so on to attack collective bargaining structures in countries in need of bailout. Of course, as this audience knows, it was the attack on sectoral collective bargaining in Ireland through the mechanism of competition law, which led the ICTU establishing unequivocally the right of the self-employed to collective bargaining in the European Social Rights Committee in December 2018. The reversal of austerity policies and the election of a socialist government in Spain led to a Spanish law passed on the 28th of December last year, which provided that sectoral collective agreements will from now on take precedence over enterprise agreements and establish that collective bargaining is once again to be the central instrument in negotiating wages and working conditions. And in New Zealand, A bill is currently being debated before Parliament to establish widespread sectoral collective bargaining. Indeed, collective bargaining is now widely advocated globally as the antidote to inequality, falling levels of real pay, and hence a means of increasing demand in the economies of the countries of the world, including advocacy by the ILO, the OECD, and even by the IMF. Conclusion. If the UK government is serious about the establishment of a sectoral collective agreement for ferry services in Europe, that will be a momentous achievement for seafarers. But it's hard not to be cynical about the present UK government for reasons too obvious to mention. In any event, it must be said that the real problem faced by the 786 sacked seafarers was that 42 years of anti-union legislation have neutered the capacity of British unions to defend their members. Of those legislative restrictions, the single most significant reform in this case would be to restore the right to organise solidarity action. If dockers, tugboat crew, pilots, cleaners, ship repairers, refuse disposal teams, refuelling workers, trailer loaders, and lorry drivers could have been called upon to take solidarity action and refuse to service P&O ships, as indeed the dockers in Rotterdam have done, this dispute would have been quickly ended. Solidarity would have harnessed the common outrage at what happened at P&O. In the UK, the unions, as we've seen, are legally prohibited from organising industrial action by workers who are not the direct employees of those in dispute. The removal of this one prohibition would facilitate the solution which the government seem now to accept, a collective agreement for the sector. What is essential is the restoration of the freedom of unions to defend their members, and legislation guaranteeing unions the legal space protected from injunctions and damages claims in which to organize industrial action. That is the only legal way to rebalance power at the workplace and give workers the leverage to resist tactics like those of P&O. This is the only way to fight back against the all-out attack on the incomes and conditions of the working class, which is now being waged in Britain. Thank you very much for listening.